Hello, and thank you for listening to this podcast. My name is Karen Killalea. I am a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. So, as usual, before we kick off, just some housekeeping. If you are listening in from your usual podcast app, you'll find any resource documents that we reference together with speaker information in the description. If you have clicked on the media player link sent to you by email, then you will be able to find the information in the notes section. As always, this podcast contains a general overview of developments in the law in Ireland regarding contractual retirement ages. It does not constitute legal advice, but if you have a specific situation or question, please do seek tailored legal advice. Last but not least, please don't forget to subscribe on Apple Podcasts, Spotify, or Google Podcasts. Okay, so I'm joined today again by my colleague Kieran Lungig, who's an associate on the employment team here at Maples. And in this podcast, we are going to take a look at the Employment Contractual Retirement Ages Act 2025. So we just refer to it as the Act in this podcast. We thought we would talk about this in this podcast because it's something that is coming up quite a lot in practice. So we wanted to share some of our experience and just talk through the changes that are coming down the tracks. So it's a significant enough piece of legislation, and it is going to change how employers approach the use of contractual retirement ages in Ireland. So Ciara and I are going to walk through the key provisions of the Act, give you a little update on its current status. There is a new consent-based approach to using mandatory retirement ages, which Ciara is going to explain. There are some important technical notice requirements, and we will also recap on what the employer's new duties are under the Act. We'll take a look at offences and penalties, and we'll also just give you some practical tips to assist employers with preparation for retirement. Okay, so Ciara, let's kick off. Could you just give us an overview of the status of the Act at the moment? It's not in effect just yet. What can we expect in terms of it coming into force?
Yes, absolutely, no problem. So, the Employment Contractual Retirement Ages Act 2025 has passed through both houses of the Oireachtas, the Dáil, and the Seanad, and has been signed into law by the President as of 16th of December 2025. However, as you say, the Act is not effective until a ministerial order is made to commence the legislation. The Workplace Relations Commission must also publish a code of practice on the Act, which will provide some clarification. And we are somewhat in a holding pattern for now as we await commencement. It is hard to say exactly when this will be, but it is important for employers to be aware what is coming down the tracks.
Yeah, perfect. Thanks. So, as you say, it has been signed for several months now, and yeah, I think there's a lot of employers out there waiting to see when will this actually be commenced. So, look, as you say, let's walk through it in any event so that we are as prepared as possible. It's going to introduce some fairly significant changes, and in particular, it brings in what we're calling a sort of a consent-based approach to contractual retirement ages. So, do you want to just explain what that means in practice?
Yes, and that is really the heart of the Act. So once commenced, the Act will require a consent based approach to contractual retirement ages. What this means is that employees who are subject to contractual retirement age below the state pension age, which is currently 66, may notify their employer in writing that they do not consent to retire at the contractual retirement age. So, in other words, if the contractual retirement age is, for example, 65 years of age, then an employee can indicate that they do not agree to retire at age 65, and the employer will then need to engage with that request.
Perfect. Okay, so a pretty significant change. There are some technical notice requirements that an employee must follow when issuing that notice of non-consent. So, do you just want to briefly summarize what those are?
Yes, the employee's written notice of consent must be given within specified time limits. The general rule is that notice must be provided at least 3 months, but not more than 1 year before the date on which the employee would reach the contractual retirement age. So, in the example I've mentioned, that would mean 3 months before the employee reaches age 65. In practice, employers may require that employees wishing to make this notification must do so up to 6 months in advance. However, this should be clearly communicated in company policies or in contracts.
Okay, perfect. So what happens after the employee issues the non-consent notice? So can the employer go ahead and mandatorily require the employee to retire at age 65, just to you continue with your example? Or does this mean that the employee has the right to stay on in employment until age 66, which, as you said, is currently the state pensionable age in Ireland?
Well, there are a couple of ways that this can develop. Firstly, employers must provide a reasoned reply to the non consent notice within 1 month of notification, which sets out the reasons for the contractual retirement age. If an employer does not provide that reasoned written reply, the employee can only be retired on either a date the employee agrees to or the date on which they reach age 66, whichever comes first.
Okay, so if the employer provides the reasoned reply within 1 month, what happens? Is it then possible to go ahead and rely on that earlier contractual retirement age? Again, just to use your example, age 65.
Yes, potentially. If the employer does provide the reasoned reply, then it may be possible to enforce the contractual retirement age, but only where the employer can show that the contractual retirement age is objective and reasonably justified by a legitimate aim of the employer. The means of achieving the aim must be shown to be appropriate and necessary, and this is perhaps the crux of the legislation from the employer's perspective.
Okay, that's great. Thanks, Kira. So the Act does give some flexibility to allow retirement below that state pension age of 66, but equally, I suppose it allows employees to flag their non-consent to an earlier retirement age. But ultimately, if the contractual retirement age is capable of objective justification, as we will talk about a little bit later, it may be relied upon. So you've also mentioned the technical compliance conditions, the notice conditions, if you like, applying both to the employee and the employer, and they are important. Another helpful piece just to bear in mind is that certain employment relationships are excluded from the scope of the Act. So an employment relationship that is subject to a maximum retirement age which is prescribed by law, or one that is subject to a statutory maximum service limit, and those are relatively rare. Those employment relationships are not within the scope of the Act, but I think we can safely say the vast majority of employment relationships, in fact, are. So, okay, look, all of that's very helpful for employers to bear in mind. The Act imposes very significant consequences for non-compliance. So do you want to just walk us through some of the offences and penalties?
Yes, it very interestingly, the Act creates a new offence. So, failure without reasonable cause to provide a reasoned written reply to the employee's non consent notice will be a new offence, punishable by a Class A fine of up to €5,000 or imprisonment of up to 12 months or both. Importantly, there is potential liability for both the company and responsible officers. So, this is a very significant and an important piece to bear in mind. In addition to the criminal offence, the WRC may award compensation of up to 2 years gross remuneration or €40,000, whichever is the greater, for breaches of the legislation. And of course, there's the continued need to ensure that any enforced retirement age is objectively justified to mitigate exposure to age discrimination claims, which must remain a live risk.
Yes, very important point. And additionally, it's probably good just to recall that, as with many other pieces of Irish employment legislation, employers cannot penalise or threaten to penalise employees who assert their rights under the Act. So, in this case, the definition of penalisation is very similar to the definition of penalisation under the protected disclosures legislation. So it covers a whole range of potential penalisation, such as, referral for a medical assessment, a poor performance review, and so forth. So there's quite a long list there. And an employee has an individual right of action. So in addition to what you mentioned above, which is obviously a concern for directors and officers, an employee has an individual right of action action before the WRC to recover compensation. So, look, just to round off, it might be helpful to go through some practical tips for employers. What do you think employers can be doing now to prepare for the entry into force of the Act?
Well, there are quite a number of steps employers can take at this point. Firstly, employers should identify employees who are subject to a contractual retirement age below 66 and are due to reach this age over the next 12 months. And that's a relatively straightforward exercise for HR teams within employer entities to start looking at the data. And this will make sure employers are aware of which employees may commence the notification process. Secondly, employers should also review and update their retirement related policies and procedures. So, if you have a contractual retirement age in place, now is the time to make sure that is clearly documented and that any employer notification windows are set out in clear, accessible terms. Thirdly, employers should develop an objective justification framework linked to legitimate aims such as workforce planning and succession. If an employer is going to seek to enforce a contractual retirement age in circumstances where an employee has issued a non consent notice, the employer will need to demonstrate that this is objectively justified. Employers should also prepare procedures and templates for acknowledging and issuing reasoned written replies to non consent notices. Employers will have 1 month to provide a written reasoned reply. As we mentioned, failure to do so is a criminal offence. So, having a good template, a clear process in place is essential, particularly where there's a time limit within which an employer is operating.
Okay, that's great. Very helpful practical tips there. You mentioned a few moments ago that we are expecting a new code of practice, and we will update listeners as soon as that is published. In the meantime, we do have an existing code of practice on longer working. It's a really, really useful resource, and again, we will just pop that into the show notes. We've also spoken about it before, but do you want to just give us a quick recap on the existing statutory code of practice on longer working and its value as a resource?
Yes, absolutely. The Industrial Relations Act 1990 Code of Practice on Longer Working Declaration Order 2017, or the Code of Practice as we'll call it for today's purposes, came into effect back in January 2018. Essentially, it provides best practice guidelines for employers and employees on managing the retirement process. And as you say, while we await the WRC Code of Practice on the Employment Contractual Retirement Ages Act, the 2017 Code of Practice is very informative and it's a useful guide for employers dealing with requests to work longer. The Code of Practice sets out best principles and practices for the lead up to retirement, the conversations, the planning, how you respond when someone says they want to keep working. It covers four main areas. So, utilizing the skills and experience of older workers, objective justification, standard retirement arrangements, and handling requests for longer work.
Perfect. And look, we're going to dive in to one or two of those, but in particular, maybe we might talk about objective justification for a moment. Now, we did cover this in a previous podcast, and we will put the link to that previous podcast into the show notes, where we did a slightly deeper dive on objective justification. But I think it's probably helpful just to recap on the key principles. And I think there are two really helpful cases that illustrate how the WRC and the courts approach objective justification in practice. Like that remains a very live concept and a very important concept in terms of relying on contractual retirement ages. So those two decisions are the Mallon versus Minister for Justice, which is a decision of the Supreme Court, and the second is a WRC decision, Mr. Thomas Doolan versus Air Business. So do you want to please just give us a brief overview of the key principles from those two cases?
Yes, no problem at all. The first case that you mentioned, the Seamus Mallon versus Minister for Justice, was a Supreme Court decision, as you say. And in that case, the Supreme Court upheld the mandatory retirement age of 70 for revenue sheriffs. So the court found that a retirement age of 70 across the public service and state agencies was not disproportionate and met a legitimate objective. For example, it enabled the state to plan for recruitment of a replacement sheriff, and it allowed the retiring sheriff to plan for their retirement. So, this decision provided welcome clarity on how the legality of mandatory retirement ages is actually to be assessed.
Yeah, very, very helpful decision, and I think lots of practitioners were very pleased to receive that decision. Particularly important also in terms of clarifying that employers are not expected to conduct a case by case or role by role assessment when attempting to justify a mandatory or contractual retirement age. Those contractual retirement ages remain permissible, but as you say, they must be tied to a legitimate aim of the business, and the means of achieving that legitimate aim must be appropriate and necessary. Interestingly, in the Mallon case, as we recall, the mandatory retirement age was justified on the basis of a number of different reasons, which included resource planning, intergenerational fairness, age balance, and consistency. Interesting also that the financial implications on Mr. Mallon were taken into consideration by the Supreme Court in that case. So, do you want to just briefly recap on the Doolan and Eyre decision?
Yes, on the other side of the coin, we have the 2023 WRC decision, the Doolan versus Air Business Aircom Limited. So in this case, the WRC did not agree with the employer's objective justification of a mandatory retirement age of 65 for a desktop support agent. The employee had formally requested to continue working, but this was refused on grounds of health and safety and fairness for younger employees. And the WRC carried out a detailed analysis and found that the mandatory retirement age could not be objectively justified on that basis. It pointed out that the employee was relatively junior, worked at a desk-based job, and that his continued service was unlikely to hinder the career progression of his junior colleagues. So the WRC made an order that the employee be reinstated to his role on the basis that the mandatory retirement age was actually in fact discriminatory.
That's great. Thanks. Yes. So the cases really, and particularly the latter case, help just reinforce the point that employers need to be able to demonstrate that they've done the analysis of the contractual retirement age and it does actually contribute to whatever legitimate aim is being relied upon. And obviously, the use of that contractual retirement age again just needs to be proportionate. It needs to be appropriate and necessary. Okay, look, let's shift gears and let's talk a little bit about requests by employees to work longer and to work beyond the contractual retirement age. We see this coming up quite a lot in practice. So, look, do you want to just talk us through, I suppose, even starting with the code of practice, just talk us through what the recommended structure is for responding to that type of request?
Yes, no problem. And as you say, the code of practice is a very helpful starting position and it sets out a very clear procedure. So if an employee wants to work beyond the contractual retirement age, they should make a written request at least 3 months before the intended retirement date. And that should then be followed up with a meeting organized by the employer. The employer's role here, the employer must listen to the employee and react accordingly. This isn't a tick the box exercise, and any decision has to be made on fair and objective grounds. From the employee's perspective, they should be thinking about whether they can still do the job that's to the required standard, whether flexible working or an alternative role might work, how long an extension they're looking for, and what the pension contract implications might be if they do remain working longer. Employers need to ask themselves, can we still justify retirement on a legitimate and objective basis? They should be applying consistent criteria across the organization and thinking about how any new arrangement would work contractually, potentially exploring, for example, and this comes up quite often in practice for us, a fixed term contract, or considering whether the request could be accommodated through a flexible working arrangement or a different role, perhaps.
Okay, perfect. So if the employer has considered all of that, as you mentioned there, there's a few things to think about, including the sort of contractual arrangements that are put in place or amendments. But once that decision has been made, what happens next?
Well, the decision should be communicated as early as possible. If the employer says yes and offers a fixed term contract, the period should be clearly specified, how long, what the terms are, and making it clear that any decision is based on this individual case and doesn't set a precedent for all employees.
Okay, and if there's a refusal for the request, any thoughts?
Then the grounds for the refusal need to be clearly set out and communicated to the employee. And ideally, doing that in a meeting is the best approach. The employee needs to understand why and to feel that their case has genuinely been considered and properly thought out. Transparency is key, and importantly, an employee should have access to an appeals mechanism. The normal appeals process following a grievance procedure, for example, and the code of practice also acknowledges that employees can bring a colleague to any of these meetings with them should they wish to do so.
Okay, so thanks for that, Kira. We await an update in terms of when the act will be commenced, and hopefully we will see the publication of the code of practice in the short term. So for now, thank you for listening to the Maples Group Irish Employment Law podcast. As always, if you have any questions or queries on any of the material covered today or on employment legal